B, change the 17th to the 24th, which is today. Okay? All right, that's out of the way. The first thing I would like to do is, we were trying to get everything done in one session last time, and we kind of raced through things. So there are a few things that people have requested that we go over again and maybe flesh out some stuff, go into a little more detail about it. The first one was demurrers. And so you've got in front of you Kaylee H. And Kaylee H was discussed on the demurrer cheat sheet, but now you've got a copy of the case. It's, you don't have it? Raymond G is the top one. I think they're stapled together. And then Kaylee H is the second one. And Kaylee H talks about, and actually they refer to it as a motion akin to demurrer, but you can just use the word demurrer in your courtroom. The judges will all know what you mean. And again, just to walk you through it, what is a demurrer? Can anybody describe that for me? And yes, there are more gift cards. Mr. Allen.
Yes, it's an attack on the face of the plea.
Okay. And how do you determine if you have a demurrer?
Whether the statement standing alone states the cause of action.
Exactly. Thank you. Under the law, does the statement in the petition, the allegation in the petition, just reading that, so at this point you haven't read the detention report, you're just looking at the petition, you're looking at each cause of action in the petition, and you're asking yourself, just what it states there, is that under the law an appropriate allegation to be made that if everything was true would result in jurisdiction in this court? And it's a very, very important thing that you do, not because you're going to have a demurrer every day or every week or even one a year, but because that looking at the petition, looking at the allegation and questioning it, that is going to be a very, very useful thing for you to do, especially those of you who are young attorneys. It's absolutely critical in almost every case that you look from the allegation in the petition to the actual code section. And one of the things that was brought to my attention this week is that some of your courtrooms do not even have a WIC code in them. I don't know how you can do your job. I mean, well, let me correct that. You can't do your job in a courtroom without a Welfare and Institutions Code book in it, unless you have the app. And there is an app. I have the app. It's not required because it's $4.99 or $5.99, but just search in your app store for California Welfare and Institutions Code 2016, and it's out. The new one comes out about 2 weeks into January every year, and it's very searchable. It's very nice. It's easy to find the code sections, but you've got to be referring to the Welfare and Institutions Code. You've got to be referring to it at least with every detention you get, if not with every case you're hearing, because every hearing has a title. You're either at a 2-1E hearing or a detention or an adjudication or a 2-1F or a 364. And every single one of those hearings is described in the Welfare and Institutions Code. And it's going to be, the words that are contained in WIC are going to apply to your case differently depending on what the facts are. So I still, after all of these years, still look up the code on practically every hearing that I do. Especially with 2-1E, 2-1F, 2-2, you absolutely, you need to be reading those codes every single time you're having one of those hearings. And if you're ever, thinking about the structure of your argument, the structure of your argument is assisted by that, because you just start by saying, Your Honor, today we're at a 364 hearing where the court shall terminate jurisdiction on this case unless blah, 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 blah. And now everybody knows what they're talking about, and your argument better than address that statement that you just made. If it doesn't address that statement, if it doesn't provide, if it's not relevant to the code, then I don't know what you're doing at the hearing, and neither will the judge. So getting back to demurrer. So that's what a demurrer is. When do you do it? Someone answered that question correctly last time. Right after the judge says, do the parties waive a reading of the petition and enter a general denial? And your answer is, on behalf of father, no, Your Honor, we will be demurring to the petition. You can tell them exactly the allegation you're demurring to. We are demurring to the C against the stepfather on the grounds that he emotionally abused his stepdaughter when his own biological children are not named in the petition as being at risk. That was one of the things we discussed last time. And there are 3 good examples. In addition to that one, there are 3 more examples on the detention cheat sheet of times when you're going to want to demur. And then once you've told the judge what you are demurring to, then you say, I would ask the court to set a briefing schedule. And the judge will say, okay, you know, March 4th for the demurrer, the department has till March 10th to respond, and we'll have the hearing on March 12th. And sometimes, as we discussed last time with Ms. Hannigan's, the minute she got her demurrer filed and the department had a chance to read it, and more importantly, probably the county council assigned to the case had a chance to give it to their supervisor, everybody agreed that they just needed to call up the social worker and get an amended petition. If you do not, just get the department rolling over, then what you're going to need to do is have a hearing. This is not a hearing that you're going to need any witnesses for. It's not a hearing that you're going to need any additional evidence for, because again, the entire hearing is just about that petition, that allegation in the petition, and whether or not it is appropriate under the law, whether or not those exact words would be jurisdictional under the law. And so it's just a legal argument that needs to be made. And Kaylee H. is the only case I'm aware of involving a demurrer in dependency court, and it does arise out of a kind of a complicated legal guardianship situation, but what you'll get if you read that case is an idea of the kinds of situations when a demurrer is going to be appropriate, when things are pretty weird, when the relationships are not clear, when people have allegations against them who don't live in the home. That's the kind of thing that's going to make you perk up and want to look and examine and maybe even call your supervisor to see if a demurrer is appropriate. Any questions about demurrers? Great. Now moving on, we were talking about the things that you're going to do before you talk to the client, after you talk to the client, and while you're talking to the client. And one of the first things that you want to do when you're with the client is, Kathy Anderson has an expression which her attorneys have probably all heard. I don't think any of the first attorneys have heard it yet though, and it's judge the case, not the client. And that's really, really important. It says a lot right there. And remember we talked about very briefly about in the activity sheet not writing down things like client was crazy, dad had a meltdown, mom was ridiculous. Those are not things that we are writing down, and more importantly, they're not relevant. They have nothing to do with the hearing that you're conducting. And the truth is, it probably says more about us when we want to write those things down than it says about our client. Because our client is, having one of the worst days of their life. So a large amount of leeway needs to be given to them. What you need to be doing is focusing on what the legal solutions are to the situation that they're finding themselves in. You've got to be identifying what their defense is and figuring out what you need to do to prove that defense or to verify that it actually exists. And you've got to be making those notes in your activity sheet. Because when they say things, what should be going through your mind is, okay, what would I need to prove that? How do I take what my client is telling me and turn that into an actual argument that I could make at a trial? So you're jotting down notes for who you want to subpoena, records that you may need to be looking at, cases that you need to read because you might need to apply the story that your client is telling you to that case and try to make them more similar. There are lots of ways that you can do this. There are lots of things you can tell your client to do to help him along, to make your case fit perfectly under, for example, in Ray AE that we talked about last week. So those are the notes you want to be making on the activity sheet. What is the defense, and what are you going to need to do between now and the adjudication date to make sure that you can prove that defense, or tell your client why that defense isn't appropriate. You know, the witnesses turned out to not say what you thought they would after we talked to them. We subpoenaed the medical records and they didn't come back. We subpoenaed the call log because you told me there had been no other calls to the home. We subpoenaed the call log from the police department, and unfortunately there were 14 calls to your home in the last 2 years. So you need to do the work though. You don't blow the client off and their potential defense off at the detention hearing just because they're expressing the defense at the top of their voice. Or they need to wander around and walk around the table while they're telling you. Or because they need to get something off their chest. And that's another technique. Those of you who went to the mental health workshop I did a couple of years ago will be familiar with this technique. But when your client clearly needs to get stuff off their chest before they can listen to you, you have to let them get it off your chest. And the way I do it is I pull out a blank piece of paper and I start writing down what they're saying. I'm making a bullet list. And then when they go back and they repeat themselves, I say, mother's out to get you ever since you won custody. I've got that one. That was number one. That was the first thing you told me. So that eventually they realize that they don't need to repeat themselves, that you've heard them, that you've taken notes, that those notes are going to go in the file. And if you just keep saying anything else, anything else, anything else, I guarantee you the end will come much quicker than it will come if you are trying to argue with them about whether they're going to listen to you first or you're going to listen to them first. So listen to them, take those notes, because that's your proof that you are in fact listening to them. And you may even pull that piece of paper out a month or two down the line and say, remember I understand all of these things. And here, and sometimes I'll say this, you know, numbers 1 and 2, I'm really going to run with those. I think that's where your defense lies. And they're not lawyers. They can't be expected to give you a perfect, you know, defense in their comments to you, in their explanation to you. They're going to throw out all the information that they think is relevant. It's your job to take those puzzle pieces and put them together in a coherent picture that will, you know, be convincing at the time of trial. So again, you're going to need to really pay attention to them, really let them feel that they're understood, and you're going to need to build a little trust. One of the ways you build a trust, this happens to be another expression from Kathy Anderson, hopefully her firm is familiar with, and that is when you're talking to your client, you can explain to them what things are going to happen, what you're not going to be able to stop from happening, and what you are going to argue to stop from happening. But more importantly, you're going to tell them, we are going to circle the legal wagons around you. We're circling the wagons to protect your legal rights. I would not use the word constitutional rights, because they're not all constitutional rights. As a matter of fact, most of the rights that they have are statutory rights. And you can't live in a world where you pretend the internet doesn't exist. And, you know, we should all really acknowledge that if our kid was going to get detained, if anybody told us anything was wrong with our kid, probably the first thing we would do is go to the internet and Google, you know, whatever the problem was. And when they Google dependency court, well, hopefully most of you have done it. Raise your hand if you've actually Googled, my child was taken away by DCFS. Wow, okay. Please, you need to do that. Suddenly, it will be like the light, you know, opening up above your head. Suddenly you will understand why your clients are saying what they're saying to you at detention hearings. That stuff is not, they don't all just have the same nightmare the night before they come to court. They're getting this off the internet. That stuff about, you know, sovereign citizens, that's a big, and when they say that, when they mention the word sovereign citizens, I just immediately say, you've been on the internet. And then I explain to them, you need to be real careful about what you're finding on the internet. Now, there are a couple of lawyers who are our competitors. You know, we are not competing with them, but, you know, they see it that way. And they've got actually some pretty good websites out there that really do a good job of explaining what the law is, what the different hearings are, and I know it's one of the goals of our organization to have, you know, a good website too, and I'm sure that's coming down the line. But you know, you don't want to refer anyone to them because, you know, they'll get their legal advice from you. But you need to understand, you need to visit some of these websites yourself, and you need to really see, you know, what they're saying out there, because it's a lot of crap. It's a lot of stuff that really sets them off and sets them up to be walking into the courtroom and, you know, just calling into question, you know, the judge's authority, the courthouse's authority, the statutory authority, etc. And understanding it really can allow you to think at your leisure of the arguments that you would use to counteract that. The main one being that your child has been detained by these people. I want to help you get your child back, and therefore we've got to understand what this system is about. And the system is meant to protect children. It overreaches by a mile. On any given day, it is overreaching by a mile, protecting lots of children that don't need to be protected. And I understand that, you know, you're very clear that that's the situation in your case. But I can't just walk into court and say, that's the way you feel. I've got to put together a case. And I've got to use these laws, and I've got to use your story and fit it into the law in order to convince the judge. So do try to make sure that your client understands what's going on. And besides just helping them to understand a little bit about the system, help them to understand burdens of proof. That's going to become really important to them. And you need them to understand prima facie, preponderance of the evidence, and beyond a reasonable doubt, because a lot of them have familiarity with beyond a reasonable doubt. You know, they all watch TV. Rosetta?
Oh, I was just going to say, I just took my phone out of Google, my child was taken, and I found a list of 10 ways to beat DCFS. And number 1 is get a private attorney, because court-appointed attorneys have heavy caseload, and they'll only be able to talk to you for a few minutes before your case is closed.
Well, actually, I'm impressed with that, because that's at least true. If all of the advice on the internet was that true, I really wouldn't have any problem with it. You know, and good. Caseload reduction. So thank you, Rosetta. But the other stuff is the stuff I really want you to see, is the stuff that you're going to look at your client and think they're crazy, and in fact, they're not crazy. They are informed. They took it upon themselves to try to get informed before they came to this hearing, and they just, you know, pressed the wrong button and found the wrong website. So back to burdens of proof. This is real easy. I recommend starting with beyond a reasonable doubt, because that's what they've heard about. And if they have a criminal case, there's a nice little segue, you know, right into it. And you can tell them everybody knows, you know, what the burden of proof is in a criminal court. It's beyond a reasonable doubt. And you can tell them that means that in criminal court, in order to find you guilty of a crime, the DA has to prove every single element of that crime. And they have to prove it to not 1, not 10, but every single one of 12 jurors. And they have to convince each and every one of those 12 jurors beyond a reasonable doubt. So like, you know, 95, 98% sure. They have to be really, really sure, beyond a reasonable doubt, in order to convict you. Here in our court, at the adjudication, in order to sustain the petition against you, the county council has to convince just one person, one judge, that these things have happened by preponderance of the evidence. And I explain that as 50-50 plus a hair. And wherever that hair lands, that's the preponderance of the evidence. And at this hearing that we're at, this detention hearing where we are today, the burden of proof is prima facie. Prima facie is Latin for first look. It's the judge is going to give it a first look and see if the story passes muster, and if it is, that's the prima facie evidence. Prima facie is almost never going to be a standard that you can beat at detention. I've attached Raymond G. And Raymond G. is the only case I know of that, published case, where the appellate court said that the department fell short of the prima facie standard. It's about a medical neglect case. It's very, very fact dependent. But I would read it just because you need to know what the law says. And there is, you know, your clients are going to be able to tell when you're kind of talking. I can't think of a polite way to say it. When you're talking out of your nether regions, and when you really do know what you're talking about, when you really do understand the law. And let's face it, a lot of you are young. A lot of you are right out of law school. And a lot of you, the clients look at and say, how long have you been practicing law? And I always tell my lawyers to just include me in their estimate and to say, well, both my supervisor and I are going to help you, and between us we have 35 years of experience. So that usually, I've never had that not be the end of the discussion. Because it is the truth. You do have supervisors. Your supervisors have a lot of experience, and it's important that that the clients know that. So, going back to Raymond G. just for a second, because you're going to read it. I've been instructed by several of your supervisors and directors. Please do not go off and think you see a Raymond G. or even MCLE H argument for that matter, without running it by somebody, without running it by a supervisor. The goal of these trainings are to help you be better lawyers, not to embarrass you in court. So I want to make sure that you understand that prima facie is a burden that is very, very easily reached by the department. It is almost never the basis for your detention argument. Now, last time we discussed this, and so for another gift card, what is the argument that you want to make and that the judges want to see you make at detention hearings? Wait. Yeah, oh, we're doing raising hands this time because, actually, let me go here.
If there are reasonable means to protect.
Exactly. That is so right. That there are reasonable services available that can allow the child to remain in the home. And what accompanies that? There is an objection that you will want to make to the court making a certain finding. What finding, in connection with that, do you want to object to the court making? Yes.
That there are no reasonable means to protect without removing the child.
No, because that's the argument you want to make. What's the objection you want to make to a finding of the court, or what's the finding of the court?
That there were no reasonable means.
Reasonable efforts.
Reasonable efforts.
Yes, that there were, you want to object to the court making a finding that reasonable efforts were made to avoid detention. And why is it so important that we make the reasonable efforts finding? What actually happens in the case to get the department's attention anytime you make a reasonable efforts finding? Come on, somebody besides Mr. Allen. Ms. Pham.
No federal funding for the case.
Just for that day, right?
No, for the case, the whole case.
Forever?
Forever.
Exactly. We passed that one down to her. Yeah. Yeah. The department loses all federal funding for that case in perpetuity for the life of that case. And the funding comes out of, I don't know if it comes out of, does anybody know if it comes out of DCFS's pocket personally?
County.
Or just the county? The county. But DCFS is held accountable, right? For that. And heads will roll. And, it's very satisfying when you think of that. And by the way, if you don't know the reasons why or the outcomes and effects of some of the things we're telling you to do, ask your supervisor. Because that's what makes it fun. You know, when you watch the county counsel's face go white, when you actually have a reasonable efforts argument, when they get mad at you for not telling them you were going to make a reasonable efforts argument at detention, that's why. The consequences on their end are enormous. And if you are making a good, solid, reasonable efforts to avoid detention argument, you might find that they're getting on the phone and being in agreement with release, with grandma living in the home or just straight out release. You never know what you're going to get, but it's really, really important you understand the consequences of the things that you're arguing and the effects on other people. For both of those reasons, because it will help you understand why county council gets so excited about some things. Even the most casual, I'm using casual instead of lazy. County council will get really, really excited about some things and not others, and that's because of the consequences to their client. They've got a client, and remember the other thing. Their client is not on their first time at the rodeo. Their client is not scared and barely processing what's happened. Their client is sitting right behind them, ready to do an adverse, something called an adverse, which basically, just trust me, it's not a good thing. And they're under a lot of pressure. So it's useful to understand that. Okay, moving on. Jill, you got a question?
No, it's okay. I can ask it then.
You sure? Okay. All questions are good questions, so there is no stupid question. The other thing you want to tell them is what things are going to look like. What things are going to look like and what things they're going to hear in the courtroom. It's really important that you say the adoption word, the A word, when you're talking to them out in the lobby, and not let them hear that word for the first time in the courtroom. Especially if they're already, very highly agitated. And, so you want to make sure that, they know that this court does have the power to do these things. That's why they have you. You are going to do everything in your power to prevent those things. You can also say something like, if it's a real simple case, you can say, listen, I can't imagine how this case could go from that to adoption ever, but it is possible, and it has happened. You've got to tell them that too. It has happened before, and tell them the circumstances under which it does happen. It happens when you decide that you're just going to blow off everything the judge says, ignore what the judge is telling you to do, that you're not going to even talk to DCFS. Those are the kinds of cases where sometimes we end up in 6 months or a year and a half or 2 years here with people having their parental rights terminated. They need to understand that, and they need to understand it from you, because of all the people in this system, you're going to be the kindest in explaining it to them. You are going to be the nicest. You'll put it in the most, calming and gentle terms. So make sure that you let them know that, and then again, that's a good time to mention the circling the legal wagons, image, and give them that image, and tell them that, you aren't just one person, that you have supervisors, that you have a firm director, that you have social worker investigators at your office, and our whole team is going to be working with you. Going on, in the detention hearing, of course, the main thing that you're going to want to be on top of is arguments for release. And again, we've properly identified what is a winning argument for release. And the winning argument, the argument that judges are waiting for you to make, is the reasonable services, lack of reasonable efforts arguments. Has anybody tried that? Has anyone made a reasonable efforts argument recently?
Yes.
How did it go?
It fell on deaf ears, more or less.
Can you remember what the basis of it was?
On record, I called the department apathetic, more or less lazy, in that they didn't keep in contact with the client. The most they did was make a few phone calls in the reasonable services section of the detention report.
Mm-hmm.
So I said that.
Who did they make the phone calls to?
To the clients. Phone calls. That was the extent of what they listed in that section, so I thought that was preposterous.
So I was reminded that I'm doing this primarily for the young attorneys, so remember, there is a section in every detention report that is titled Reasonable Efforts Made to Avoid Detention. And the paragraph under that section almost always is like 3 sentences long, and all 3 of those sentences say, we made reasonable efforts to avoid detention. And those reasonable efforts were reasonable. And we made those reasonable efforts reasonably. Like literally, seriously, okay, not literally. But, pretty much that's what they write. There is no there. And, you can often find what they did by reading the rest of the report. And so you don't want to, just because they didn't put anything there, jump to the conclusion that there were no reasonable efforts made to avoid detention. But once you don't see anything there, then you absolutely want to go and look at the rest of the report. And again,